Let's Talk Development, Season 3, Episode 11.
Hello and welcome to Let's Talk Development. This is co-hosted by CDPR and IGC. My name is Asad Rahim Khan, and while I work as a lawyer, we are extremely privileged to be joined by Justice Ayesha Malik. Her ladyship, while otherwise requiring no introduction either in the legal field or outside it, is nonetheless the first ever Justice of the Supreme Court, female Justice of the Supreme Court in the history of Pakistan. What makes this fact an outlier all the more is that Pakistan was the last country within the South Asian region to appoint a female justice to their apex judicial forum. That doesn't augur well for at least Pakistan, but Justice Ayesha Malik has nonetheless, from her time since 2022, brought so many laurels to our country's jurisprudence. We'll touch on that in just a second. Before her elevation in 2022, Justice Ayesha Malik was a judge of the Lahore High Court from March 2012, where various landmark judgments were also delivered. Her education has been diverse: Paris, New York, London, with an LLB from Pakistan College of Law and an LLM from Harvard Law School, where she was named a Landon H. Gammon Fellow for academic excellence. The other aspect, and this is clear from her jurisprudence as well as from lawyers appearing before her, is Justice Ayesha Malik's extensive experience in her own right as a practitioner in the field. She started out with a legend of the law, Mr. Fakhruddin G. Ibrahim at Fakhruddin G. Ibrahim and Co., and then very rapidly made a name for herself in corporate and litigation. From there on, starting from her elevation as a judge of the Lahore High Court and then, of course, as a justice of the Supreme Court of Pakistan, her jurisprudence has advanced constitutional rights from a citizen-centric perspective that Pakistan was very much wanting, very much in need of. And within that human rights jurisprudence, she has also looked at gender vulnerability, and far and away from these aspects also is the nuts and bolts of how institutions work, how institutions are meant to cohere, and how they all form the state of Pakistan and its functions. That too has a direct relationship with administrative law, and Justice Ayesha Malik's jurisprudence has perhaps gone, I would say, it has gone the furthest, or at least among the furthest, in clarifying administrative law and how it is meant to facilitate the citizen. So as can be gleaned from all of this, when someone is actually blazing a trail, it comes with certain plaudits, whether it was Forbes 50 over 50, the BBC list of 100 women, an honorary doctorate from the University of London, a doctorate of laws, or as an honorary bencher of Middle Temple. We are very, very privileged to speak about the law, about jurisprudence, the Supreme Court of Pakistan, and also speaking purely now as a practitioner, Justice Ayesha Malik's own approach towards adjudication, whether that's her insistence on both a fair and patient hearing to litigants, but at the same time, for the lawyer appearing before her, observing complete courtroom discipline and ensuring the most important and most cogent aspects of the case are brought to the fore. Ladyship, thank you so much. It is an honor, it's a privilege that you are joining us today. If we can get into it, Ji, from your experience on the bench, how does the quality of rule of law, of governance that you see in courtrooms translate into real consequences for things like business and investment in Pakistan? Is the issue one of enforcement or one of let's say, legislation being inadequate? And to your mind, is the way forward, some people are suggesting, alternate dispute resolution is the way forward through that? And since we touched on administrative law, I know the question is becoming a bit unwieldy. How effectively does the legal system protect employees, labor? What challenges do they face in actually accessing justice? Does our system safeguard dignity and fairness, or do you think there's a gap between legal protections and the lived realities of workers, of citizens?
Thank you, Asad. Thank you for having me and taking time out for this discussion. Your question is very long, so let's break it down. So first, let's look at the quality of the rule of law. And I'd like to first sort of make a landscape, draw the landscape as to how I see things.
Yes.
According to the World Justice Project Rule of Law Index 2025, Pakistan ranked 130 out of 143 countries. And this is important because what this means is that in terms of overall adherence to the rule of law, this index measures components such as transparency, civic participation, protection of fundamental rights, regulatory enforcement, and the working of the civil and criminal justice system. So the index is really like a scorecard which concludes on the quality of the rule of law available to the country. And for Pakistan, unfortunately, we are ranking near bottom in this index, which means our performance is not satisfactory with respect to all the components. If we look at another indicator, the World Bank Governance Indicator, that also ranks Pakistan fairly low. There, the indicators are elements such as accountability, citizen participation, political freedoms, political stability, public servants, corruption, and even the quality of governance. And again, we rank low in all the indicators, which really again says that our system of governance is neither efficient nor is it effective. So what does it mean for citizens? Well, for the ordinary citizen, it means that both in terms of the rule of law and in terms of governance of the system, it's not effective and it's not in any manner connected between, there's no connection for the citizen and the form of governance where state institutions, in my opinion, are out of touch with the lived realities of ordinary people. This disconnect becomes the basic cause of litigation because individuals are then forced to seek the court's indulgence on issues that affect their daily lives, their business, their ability to exercise their constitutional rights. Now, let me illustrate. There is a lot of litigation against government-issued policies, departmental decisions and actions, and against regulatory authorities. The subject of tax is litigated on very frequently. There is a lot of litigation with respect to the frequent changes in policy, in law, and coercive recovery. In this context, public spending is litigated on, accountability is litigated on, there is a lack of transparency, information, and stakeholder participation, so regulatory decisions are litigated on. Yes. Terms and conditions of service are heavily litigated on because there are delays in promotions, disciplinary proceedings, non-payment of salaries. The list goes on and it's endless. In the same way, labor and employment disputes are frequently brought to court because of delay in decision-making, arbitrariness, and discrimination. So the overall feeling of unfairness is what prompts litigation. Decisions related to regulatory authorities are questioned not only on grounds of arbitrariness, but also on grounds of independence, enforcement, and more importantly, on discrimination. When we look at other disputes that individuals bring against on issues related to, say, property or their business, again, litigation is prompted because there is no planning, environment issues, encroachment issues, housing issues, even something as simple as delivery of connectivity for electricity or gas or billing issues prompts litigation. So to answer your question, what does this translate for the court? It basically means weak governance leads to excessive litigation. And it means that citizens litigate to assert their right, they litigate to be heard, they litigate to be treated as per law. Courts are seen as a neutral forum where due process and fairness will ensure a fair hearing.
Yes.
And there is also a lack of trust and confidence in the system, which means that all decisions, practically everything is litigated on because people don't really have confidence in the decision-making process or even in the authority. So credibility becomes an issue. People litigate because they feel compelled and they feel that the only way for them to be heard fairly will be through the court. Now, this perception in itself causes litigation.
Yes.
So for the government and systems, it means a lot of time is spent and money is spent on defending their decisions, their policies and their actions, which unfortunately with time reveals that the issues repeat and there's very little change. I have almost 14, this is my 15th year on the bench, and I see that issues are constantly repeated. We are constantly repeating things, and then the element of change is not really visible. The process of reform, of improving procedures, of facilitating citizens is also negligible. So litigation becomes a means not only to ensure rights, but it also becomes a means to delay matters, to put pressure on other sides, to negotiate for a better outcome. And so unfortunately, we've become a very litigious country and we litigate literally on everything. So to summarize, for the court, litigation represents weakness of governance with internal decision-making, lacks clarity, consistency, it lacks time frames and adherence to the law. This carries a broader cost, not only for individuals, but for businesses and investors who depend on consistency, clarity, time frame, and enforcement. Effectively, the volume of the litigation against the government reflects that governance and rule of law, as per the indexes that I said, really do not impact positively the lives of ordinary people. So now you said, what's the way forward?
Yes.
Now, based on my experience, the way forward is the focus on poor enforcement.
Right.
We have policies, we have laws, rules, we have legal and regulatory frameworks. What we are missing in all of this is an enforcement mechanism with monitoring, reporting, compliance, with data. We need to ensure that the law is achieving the objective that it sets out to achieve. The entire purpose of creating a legal and regulatory framework is to deliver its objective, is to deliver the service to the citizen. And without that delivery, no system can really say that it's functioning effectively, can say that it is delivering the service that the government is out there to deliver. What courts see time and time again is that the application of law is missing, arbitrariness in decision-making, inconsistency in decision-making, discrimination, and most of all, what this does is that there is an absolute erosion of trust and confidence in governance. And when I say erosion of trust and confidence, we're looking at the ordinary citizen with the ordinary and most simplest of issues. There is an absolute erosion of trust when they can't go to the government or to any simple counter to say, I didn't receive my salary,
Yes.
but have to come and litigate on it for years to say, I haven't received my salary, my bill is incorrect, I have not been appointed, I've not been promoted. It just, the unfairness of the system, imagine it from that person's point of view. This leads me to another issue, and which is very, I feel, is one of the underlying issues, and that's of behavior and mindset. A lack of systemic enforcement means that the behavior patterns and mindsets will never change. People litigate because they can litigate. People litigate because it enables them to delay or control the issue. The advantage in a systemic enforcement system is that it navigates to a large extent basic matters which affect people's lives, and it doesn't give people the ability to control any of that. So if a person has to come to court for something as simple as salary, promotion, pension, a very basic livelihood issue, then that person is really coming to the court for something which due process, which good governance could have ensured and should have ensured that it is available to them.
Yes.
So what this suggests is that governance is not paying attention to the issues of the people, and it's lopsided. The scales of balance are lopsided in favor of government and not in favor of the citizen. So in that space, courts are often required to step in to ensure that existing rules are followed, decisions are taken, and basic rights are protected. But this enforcement does not change the behavior and does not change the mindset. Avoiding the law becomes easier. People take the law into their own hands. That becomes easier. So until there is no effective enforcement system, the law really is just law on paper.
Yeah.
And the question as to whether ADR is a solution, to my mind, ADR means and includes all forms of system-made complaint redressal and dispute resolution forums, which should be made available to a citizen, so that they can efficiently and effectively resolve their dispute. Now, while some forums of this kind do exist, again, there are time lags there, and if you are contesting an issue which should be decided within months,
Yeah.
and that is decided in years, the sort of the impact of that decision absolutely lost. So ADR is a solution only if enforcement mechanisms are put into place. The law is followed in letter and spirit, people's rights are ensured, and decisions are made in a credible manner. ADR assumes a very basic system works. And so within that system, you have a dispute resolution mechanism. And an example of this, for example, is the complaint redressal cells like the Pakistan Citizens Portal, the Federal Ombudsperson, provincial portals, and so on. But there also we see that the issues are similar. There are delays in the decision making. And so often you find people coming to the court not taking the forum available simply because of a lack of trust, or because they feel that the time frame is so long that the relief will become infructuous. And there is also again another issue of accountability, of public trust, of non-functional mechanisms. ADR cannot fix that.
Yeah.
Only enforcement can fix that. So we need to shift the mindset from seeing courts as the first stop towards rebuilding trust in governance, towards effective and independent grievance redressal forums. And without really focusing on enforcement, without building on systems, you cannot restore confidence in everyday processes.
That makes a lot of sense, Ladyship, and completely agreed that ADR cannot be the silver bullet people are saying it is without an enforcement mechanism. In fact, that goes for all legislation, as you have outlined so well. You spoke about government and its direct relationship with litigation and how people have their own equation with litigation. We are, in fact, a very litigious society, as you rightly put it. Now, I'm thinking if we can touch on the business and regulatory side, which you very correctly mentioned, you've emphasized that the role of a regulator isn't to manage, isn't just to manage, rather, it's also to protect. And there's a judgment of yours, Al Baraka Bank versus Province of Punjab. To everyone listening, we'll have all of these citations in the description. So students of law, students in general, can read these and benefit from the detailed reasons provided. So in Al Baraka Ladyship, you held that the rights of the individual, which in this case was the cane grower, are superior to those of the big miller, which would suggest that the law must be viewed through its social purpose. But we also see you pull back at the same time on state overreach. So this is another case now, Commissioner Inland Revenue versus Pakistan LNG. In that decision, you warned that tax recovery shouldn't be, if I have it right, a grab and go process. That's what was written, and must respect due procedure. So between these two poles, protecting the vulnerable while curbing coercive state power, where do you find a happy medium, if there is such a happy medium, for the regulator in Pakistan?
So I think regulatory governance is very important.
Yes.
Regulators have a pivotal role. They provide the sector-specific regulatory framework, the expertise on the basis of which that sector must serve and grow. They are formed as independent authorities in public interest for structural rule-based governance. And there are many regulatory authorities like OGRA, NEPRA, SECP, and so on. Their function is to promote the purpose for which they are formed, to serve the consumer and to ensure regulatory decisions are taken lawfully for the benefit of their sector. However, what we find is that over time, regulatory framework has weakened. It does not deliver. There is regulatory capture, which means that basically the regulator is the long arm of the government doing whatever the government wants it to do. There is excessive discretion, there is poor accountability, there are conflicting mandates, there is capacity issues, which all result in litigation. And they basically, when you have these various kinds of litigation coming before the court, you really have to deal with them not only on a case-to-case basis, but also look at the larger picture of governance. So now let's look at the cane growers case. This was a case which reflected essentially on not only governance, but on how we value the input and the relevance of that cane grower. And the issue before the court was the rights of the farmer who grows the cane and sells it to the mill, the sugar mill, or the rights of the bank who was seeking to recover from the sugar mill. The court found that the basic role of the cane commissioner under the Act is regulatory, with the objective to ensure that sugar cane is delivered by the cane grower within the given time, but at the same time that payment is made to the cane grower within 15 days of delivery. It is in this context that the court held that having supplied the sugar cane on time, the cane grower has the right to claim the value of the sugar cane delivered to the sugar mill. The issue for the cane grower was the delay in payment, and that delay was not just of days or months, but of years. So there's a poor man growing the sugar cane, supplying it endlessly, but not receiving any money. The right of the cane grower, therefore, in that case, became superior to all other rights, on the basis of which the judgment finds that the cane grower is entitled to recover the value of the sugar cane from the sale of the bags of sugar before the banks are allowed to recover it. The banks claiming a superior right, as per the judgment, basically was that their right is inferior to that of the cane grower. Another example I can give you is the surface mining case. Now, in this case, there was a serious issue of air pollution, and the court again held that environment compliance lies with the Mines and Mineral Department, and that this is a step that has to be taken before projects are approved and not after projects are approved. The impact on the environment has to be looked at during the bidding time, at the feasibility time, to ensure that all relevant steps are being taken to mitigate any environment hazard. The practice is that it's once the project is approved, the contracts are signed, then the issue of pollution is looked at, which is really unfair even from the business end. So these are basic issues which show where the regulator, in my opinion, fails to discharge the actual responsibility that they've been set up for. In the same way, in the High Court, in cases pertaining to DRAP, to OGRA, and even something as simple as parking ticket, the approach has always been to understand from the regulator what their job is, what they are required to do, and how they can do it better in a way that in fact impacts their objective and therefore impacts the lives of ordinary people. It's important to recognize that governance is for the benefit of the people. It's not for the benefit of anyone else. So at the end of the day, it's a delivery of service, which is what the government is doing through its regulators. But regulators are formed as independent bodies, and independent bodies being independent of government rule. So they have to function in their own capacity, which is what a lot of my judgments look at. Now, when it comes to looking at things like recovery of tax, yes, you're right. The judgment does say that you cannot coercively just recover, because the objective there is that if you're recovering tax money, you first have to ensure due process. Due process is fundamental. Systems function best when people understand their obligation, their duty, and they are given time and space to respond. And there must be a degree of ownership in the process. So that's why compliance is encouraged, trust has to be built and durable systems have to be created. So you have to control the long arm of the state also, that you can't just go and grab whatever it feels without giving that citizen the opportunity to at least protect its property, its rights. You even see that in land acquisition cases. And that's why you find that these areas are litigated upon. That's why people question decisions that are made. But more importantly, the root cause, that's why there is a lack of trust and confidence in the system.
Yes. So when you say a lack of trust, I think that might have a direct bearing on what the state's responsibilities are. You mentioned various regulatory authorities, and rightly. One aspect of regulation, which is under-discussed, underrated, and yet clarified by yourself in the Lahore High Court as well, is competition. Just to go off of one decision, Competition Commission versus Dalda Foods, you argued that competition can't be confined to territorial boundaries, and that consumer welfare is the ultimate driver of economic growth. So in your view, how would a more aggressive, more effective enforcement of competition law maybe reshape our regulatory environment? Because this is something that you've seen very closely, and this is sadly an aspect that not much work has been done otherwise from the jurisprudential side.
So as I've already said, regulation must balance enforcement with fairness and independence and with accountability.
Yes.
Now, in the Dalda judgment, the court held that the aim of the Competition Commission as a regulator is to create a healthy market which serves the consumer's interest and structures behaviors to encourage economic activity for more equal distribution of resources and wealth. For that reason, the Competition Act gives the CCP powers to collect information, study markets, do research, conduct inquiries. These are regulatory powers meant to understand how competition works and where it is being distorted. Accordingly, the Act's objective is to promote free competition, and it's not only a structural issue but a behavioral issue which it has to deal with. So the CCP as a regulator must always act in a manner which is transparent, keeping in front of it the undertaking and the decisions that are being made in relation to it, because it has to promote something.
Yes.
Now, in Dalda, the court clarified that when you're asking for information or initiating an inquiry, this is not a punitive action. These are steps towards your regulatory process of understanding competition. The penalties follow later, but that's when you've established through due process that there has been some infringement of the law, not in the first instance that inquiry and investigation in the form of research and understanding becomes a penal consequence.
Yes.
Unfortunately, like many regulators, the CCP is also reactive and imposes high fines. I mean, it appears that fines and penalty is a good way of generating revenue, and less emphasis is done on the actual work of that regulator.
That's right.
And this can be seen just from the 2025 figures of how much penalty the CCP has imposed on various different sectors and the amount of show cause notices that they have issued. Now, while it shows that there is some work being done, maybe, and you're looking at the market and imposing penalties to regulate it, it also gives a very strong impression that whenever we look at enforcement from the regulator's point of view, it's always about, taking very strong coercive action, imposing penalty, less about understanding, more about penalty. This kind of a rigid approach discourages engagement. People stop seeking guidance and become defensive. It reduces transparency and it weakens oversight. Smaller businesses are hit harder than larger ones, and this means that people start exiting from the market. Over time, regulators are not seen as independent institutions, but are seen as a coercive arm of the state. So in the mindset and behavior, again, like I said, everything stems from that. People then become defensive in the way they take their decision. And I think it's important that a body like the CCP exists as a specialized body. It has technical members who understand market problems and take informed decisions. If we're ever to allow ourselves to grow economically, we have to step out of this mode of constantly punishing people for doing well, for making money, for taking such decisions, and focus more on trying to get rid of their issues and their problems and looking at more from a diagnostic point of view.
Right.
And one of the problems here, like I said, is regulatory capture. So when the independence of the regulator weakens, the regulator starts meeting targets through penalties and it begins to lose credibility. Competition law ultimately is about protecting the market. It works for the people, just like any other regulator. And competition law, the CCP should focus on that. By now, you would have thought that, they would have developed and understood how market structures work and how different businesses work.
Yes.
The Dalda judgment was really all about understanding first the market through inquiry and research, which became more of a penal issue, which is why the judgment had to sort of pull at the regulator and say that this is not your function. Under these provisions of law, you're not investigating, like you're not policing the sector, you are researching the sector. And I think we have to understand these mindsets if we're ever going to get any change in the way enforcement or governance is looked at.
Right. So on that, on the mindset, we spent some time in the weeds, and I'd wish to just turn the theory of law to practice. When you see these disputes, commercial disputes, contractual disputes, so they've reached the Supreme Court or the superior courts in general after years of back and forth. And when you are there, what, if we might ask, Ladyship, what have you observed about how these delays, prolonged delays, going on and on endlessly, how do they impact business confidence, commercial relationships in general, the long-term health of commercial relationships in Pakistan?
There is a substantive damage because it damages confidence, it impacts timelines, deliveries.
Right.
And there are many cases in which you see that, the delay is probably planned or it's on purpose. One of the judgments that I think it's important to talk about is this Ahmed Shakil Bhatti case, which is a 2023 judgment where it was really the issue of a post-dated check for the payment of the factory. And while hearing the case, not only was the court conscious of the timeline, the delay, but also was conscious of the fact that the court was being used in a manner that it didn't think was befitting the institution.
Right.
So the court held that the obligation to act with commercial integrity is an integral part of ethical and fair business practice and goes to the root of all commercial transactions. This case is important because it recognizes that commercial integrity lies at the heart of every business transaction where payments, performance, disputes generally are brought to court. I think, again, I go back to behavior and mindset. So when you are looking at governance, when you're looking at enforcement, and when you're looking at building economies, you also have to build behavior and thinking processes, make it more conducive and make it positive for business. This is the only way to stop this endless way of looking at litigation as a way to resolve issues. And that's why I think the court is also conscious of ADR, mediation, and encourages that because it allows parties to informally resolve their disputes and avoid reputational and operational costs that come with prolonged litigation. I think technology and case management is also an aspect that the courts look at to ensure that cases go at a particular speed and are concluded within time. But I think to put the burden only on the court system would be a bit unfair because it's also the quality of the litigation and the kind of cases that are coming. I think if one sits back and sort of makes an objective list of it, you will find that a good percentage of the cases need not come to court. They can be easily resolved. But because maybe the systems are missing, the trust, confidence is missing, the mindset is missing. Hence, there are delays. So, adjournment is a reason. Adjournments delay processes. The procedures in decision making are very long and bureaucratic. That becomes a problem. So, you also see over time the development of specialized courts. You see training that is taking place. You see that the greater use of technology. However, again, I will reiterate that while courts are there to resolve disputes, courts are not there to resolve each and every dispute.
No.
And I think at the Supreme Court level, looking at bounce checks, we need to internalize as people that is this a dispute that should be going to the Supreme Court, that a payment has not been made, or that someone due to business transactions has not rendered a payment. So we look at the coercive arm, which is 489F, and try and imprison those people. So is that how we want to resolve our disputes? So I think it's about reform. Again, it's about governance, enforcement. It's about mindset. There is a habit to litigate. There is a habit to challenge every order, to appeal and petition on every issue. And this has now become sort of the way of the law. Delay is seen as a legitimate strategy rather than failure.
Yes.
And mindset becomes a problem then. You have to learn to change the way you're doing things. Compromise may be a better way of doing things, but we prefer to litigate, build a power position, and then enter into compromise. So it's my own bargaining position that's important, not the business aspect that's important. So I think the impact of delay is not just one or two issues, it's a larger issue, and we have to move from trust and performance to caution, contingency, and dispute management. We have to understand internally as people how we want to manage disputes, as well as how our systems should manage disputes.
So mindset as a problem, I'd want to use that segue into a subject that has really inspired a lot of commentary, a lot of discussion, and certain debates within broader society. If ladyship, we could move to gender. You obviously made history as the very first woman to be appointed a Justice of the Supreme Court of Pakistan. We've already mentioned that Pakistan was the last country in South Asia to do this, but that would also make you the first to bring a woman's vantage point to issues that disproportionately affect women, as opposed to, frankly speaking, men adjudicating on women. So we've had Nadia Naz versus President of Pakistan. In that decision, you stressed that harassment laws must be read in relation to its purpose. You spoke of sensitivity to workplace power imbalances and not using narrow interpretation to maybe square a circle. But we also know, and this is equally obvious, that harassment in Pakistan is widely underreported and very infrequently punished. In fact, perhaps not even discussed as much given how rampant it is. In your view, does the promise of the law continue to fall short, and is some of this rooted in social attitudes?
I think a lot of it is rooted in mindset, in social attitudes. It's all about perspective. And when we look at gender, my biggest concern is that we are missing a gender perspective in decision making. And what that basically means is that as a woman, I look at the lived experiences and understanding that the law has towards women. And when you look at how that impacts women, there will be a gender perspective. When you have men deciding how women should behave, what women's experiences are like, it becomes a bit lopsided. And that's what Nadia Naz did. The original judgment said that harassment, if at all, at the workplace is all about sexual conduct. And it failed to recognize harassment as behavior, harassment in terms of conversation, harassment as just how people are staring or sending messages. So Nadia Naz interpreted the harassment law by looking at the gender perspective, and it looked at the hostility, the intimidating environment, it looked at discrimination, because it's in order to ensure that there is equal participation at work, harassment would also include gender bias. The judgment, what I think the important aspect of the judgment is that it sets down a reasonable woman standard. And it says that you have to look at the victim's perspective, because the victim's perspective is what is relevant in terms of acceptable behavior. In this context, you have to look at, the jokes, the messages, the behavior. What is the harm that it is causing to the victim?
Right.
And not what you perceive as the harm, but what the victim perceives as the harm, and from there develop a perspective that sets a reasonable woman standard. And I think here the bigger question is that when decisions are made without a gender perspective, what you're doing is you're discounting 50% of your population, you're discounting the impact that the law will have on that population, you discount the participation of the women, and what that in fact means is that those women then become people who have to constantly struggle and constantly bring their issues before some forum in order for them to be heard in the context that they want to be heard. So when complaints and delays are trivialized, or women are told to keep silent because it's safer than reporting issues, the environment at the workplace becomes difficult. Institution building, again, in my opinion, really means paying attention to the different perspectives.
Right.
And gender perspective for me is critical, because when decisions are made without looking at the gender perspective, without considering what the gender perspective is all about, I think it's important to outline here that gender perspective does not mean favoring women, nor does it mean creating new rights. It simply means understanding the law and the practices and the impact on women, how women see it, how it impacts women. And this perspective is important because the law is applied as if everyone stands in the same position. In practice, people in different circumstances, different situations, experience law differently, experience the system differently, and they face risks differently, they bear different costs, and that's how, rights are delayed or denied. So when you look at the perspective, the gender perspective, you looked at the lived realities, the experience of women, and you build that into the judgment. I want to give an example that it's not just about women. In a recent judgment on wedlock policy, the judgment basically looked at an administrative policy of the government and said that when you have a policy which looks at wedlock, meaning where two civil servants are married and they need to be together as a family, then the objective of the government should be to adhere to its policy. Now, the judgment does not say that a civil servant has an absolute right to the wedlock policy or to say that where should it be transferred or posted, but says that it has a legitimate expectation to be considered as per the policy.
Yes.
In that case, the petitioner before the court was a man, not a woman. And the court simply recognized the fact that as part of governance, the state has to look at family, it has to look at family rights. And unless there is no underlying public interest need, there's no need to deny someone the ability to stay with their spouse if if the work permits it. The significance here is that you have to translate formal equality into real-time working of the law. You have to look at how the law impacts people. In this case, it was an issue pertaining to a man who was invoking the wedlock policy, which he was being denied for no rightful reason. There was no reason to deny him. He didn't have any special skill set. He wasn't needed anywhere specially. He was a grade 9 employee who was unwell. His wife was unwell, and he said, we're both government servants. We want to basically be at the same place. So if the government goes to the trouble of making a policy, in this case the wedlock policy, it must adhere to its policy. And policies are not made just for, ticking boxes and to show that there is a policy. The gender perspective on the wedlock policy is that you can't pick and choose when it's okay to transfer, when it's okay to apply the policy, but you follow the policy, hence the concept of a legitimate expectation. And I think it's important to recognize the difference between an absolute right and a legitimate expectation. So as a lawyer, you understand the difference, but what it really means is that you have the right to be considered. You have the right to say that there is a policy, please consider me as per the policy. If my case falls within the ambit of the policy, I'll be granted relief. If not, I won't be. There's a difference between that and saying I have an absolute right and you have no business of transferring me. So I think it's important to understand rights, administrative policies. It's important to understand perspectives. And most importantly, it goes back to ultimately the job of governance is service to the people. It's not about their own will and need, but to ensure that their system of governance works effectively.
So I'm so glad that you spoke on the wedlock policy. We were likely going to touch on that in any event to people listening. And if I have that correctly, it's the Mubashir Iqbal Zafar case.
That's right.
We'll have that for you in the comments or in the bio to this. So, Ladyship, you spoke about the different vantage points and perhaps not empathy, but just to be able to register what the other person's perspective is. That doesn't mean creating rights. That doesn't mean going into uncharted waters. It just means being cognizant of what the other person is feeling and how they're perceiving this. In Imran versus State, you warned, now we're speaking about survivors, that conflating something like rape with fornication without proof of consent, something like that re-victimizes the survivor. It erodes her dignity. And I feel these are issues that are closely adjacent to the issues in your landmark decision in Dr. Sadat Aziz in relation to virginity testing. So the impression that is formed is that both protection and procedures for survivors need to be made much more robust. I mean, some of the statistics to do with these aspects are shocking. So would you agree in relation to protections and procedures?
I will agree with what you say. Absolutely. Robust change is necessary. So far as our criminal jurisprudence is concerned, we lag far, far behind from global practices anywhere in the world. And unfortunately for survivors, they experience a criminal justice system that is consistently suspicious of them.
Yes.
The underlying, I think, belief is that women lie and that women cannot face any kind of rape or forceful rape or sexual advancement on them. And ideas about honor, about resistance, about credibility and morality shape how the law is seen, how the issue is investigated and decided, rather than seen from the point of her dignity, violation, rather from looking at it from fair trial or equality. So it becomes difficult for women to come to court expecting justice. Changing a rape conviction into a fornication conviction not only is against the law, which is what the Imran dissent says, but it totally denies that woman of due process. A woman who, in the Imran case, this was a woman who alleged rape and was given a favorable decision from the trial court as well as from the High Court. Both courts convicted the man of raping her and sentenced him to 10 years. The Supreme Court, however, disbelieved her, and disbelieved her simply because of mythical standards of, marks of resistance not being shown, because she wasn't heard or she wasn't screaming, because she opened the door, and more so because she was divorced. Now, I don't know where all of these standards fit into the law in terms of how the law is looked at this point of view. But in my opinion, these are not relevant. These are aspects which have nothing to do with the victim and really all focus on the perpetrator. So when I say gender perspective, I'm talking about building a narrative that requires asking questions like, are we making it easier or harder for survivors to access justice? Are our procedures designed around dignity, fairness, or are they designed around, our own opinions and morality, around honor and resistance? Are we investigators and administrators, or are we people from amongst the society who are implementing the law, who are enforcing the law? I think my personal opinion on this is not relevant as a judge. What is relevant is the person who's knocked on the doors of the law to say, I need justice. So again, I think real change requires more than laws. It requires decisions being made which are grounded in law, totally away from morality. There should be no morality, especially in heinous crimes such as these. I think what's also required in order to help build a perspective, help build a narrative, is academic work, sustained writing, especially in regional languages, so that these thought processes develop beyond the courtroom. In practice, it means questioning why women repeatedly have to prove their own credibility in rape prosecutions, why civil servants are denied consideration of government policies when there is a legitimate expectation under an existing policy. More importantly, it requires questioning the representation of women in the decision-making process. This has been something I've agitated for the longest time. As you said, the first woman in the Supreme Court, which means for the first time ever a gender perspective in the Supreme Court.
That's right.
I think it's important to also look at the fact that we have a less than 2% representation of women in the High Court and the Supreme Court. So less than 2% representation for a 50% population. And not only are women not appointed, they're not even considered for appointment. You take decisions, when I say you, I mean governance takes decisions pertaining to women. But there are no women sitting there. So that aspect of women, their point of view of issues related to women are ignored. So another case that we did was related to the floods in Sindh 2 years ago. And there again, my judgment looks at how women were impacted. And I said, while there's a lot of effort on relief work, because all relief agencies are men and the decision makers are men, there are no women sitting there. So you've not really thought about women, pregnancy, childbirth, issues pertaining to women, hygiene issues pertaining to women. What is going to happen to all these women in relief camps, or what are we going to do to help save these women? I think that's important. And I think it's also important to point out that while the decision said that there must be women in every committee in the disaster management system, it took more than a year and a half to get some compliance of that judgment. So for some reason, we can't find the women to sit on these committees to simply bring forward a gender perspective. I think it's important, especially when we litigate on family issues a lot, criminal justice, when we litigate also as in service matters a lot of the litigants are women. So we do have to look at the gender perspective, and we need people to understand that it's not about advocating women's rights. It's about a perspective, and perspectives matter on the bench.
So, ladyship, on that last note, this has been a truly illuminating discussion on the intersection of development policy, judgment, and enforcement, whether that has to do with the markets, the citizen. We went into, of course, other aspects. We went into gender. Since we have you, obviously, this all falls within the broader ambit of constitutional rights. And if we could zoom out and discuss those rights in general, just for a second at the end, this is a time of great constitutional flux. And in the practice and procedure decision, the widely critiqued and greatly contentious practice and procedure decision, if I might say, your dissent held, and to my mind correctly, that the act was unlawful and that it was in fact the Supreme Court that was responsible for reshaping its own rules. You also held in the reserve seats review decision that compliance with court decisions is not a matter of discretion. You said this is a matter of constitutional fidelity. But it seems now that we're legally and institutionally drifting into completely uncharted waters. So, of course, this is without touching on any matter that's sub judice at all. But what constitutional values do you feel require safeguarding the most today?
I think when we speak of constitutional values, we first must understand the function of the Constitution.
Right.
At its core, a Constitution sets out a system which is there to serve the people. Its strength lies in whether people can rely on the values set out in that system, whether laws can work on the ground, whether rights can be enforceable. A constitution holds a diverse society together. It provides a common set of rules that apply to everyone, regardless of status or power. So when we speak of constitutional values, we speak of those values which are fundamental to any constitutional order. That includes the independence of the judiciary, separation of power, constitutional supremacy, democracy, and the rule of law. This is what regulates how power is exercised, how power is controlled, and how power is made accountable. And this also sets out the structures from where the rights of people are protected. The Constitution places human dignity as fundamental to human existence. It guarantees equality before the law. It guarantees protection of life and liberty, fair treatment, and access to justice. These are not words. These are fundamental core values which we are there to ensure are enforced. That's what we do on a daily basis. That's what we look at to ensure that these guarantees are given meaning. The Constitution commits the state to a social justice end and to protect people, the citizens, minorities, vulnerable groups, women, children. It reflects basically an understanding which is not only limited to governance, but it is about balancing the rights of the citizen and the duties of the state. So for me, it places a long-term responsibility on the state. It's not about any one government or any one movement. It's supposed to endure over time. It's supposed to grow over time. And most importantly, you have to think about your future. So if I borrow from the idea of intergenerational justice in environment law, we must recognize that the systems we shape today, the values that we give credence to today, are what will shape our future tomorrow, what the future for the coming generations will be. So we have to preserve that future. We have to preserve the capacity, the resources, the values, the constitutional governance. It's about integrity, about rights protection. It's about the future. And we can't look at short-term goals and conveniences that alter constitutional structures. There have to be meaning, has to be given to everything.
Yes.
And constitutional values acquire meaning only through consistent application. So when commitment to dignity, equality, judicial independence, and compliance are recognized and enforced, that is what brings confidence to institutions. And if we actually look at institutions, governance, and ignore transparency and accountability, that's when you have a system that's not weighing in on the citizens, but is focusing more on making it easier for governance to prevail over the people. And whenever you have that, one knows that that's not building stability, fairness, cohesiveness in society. It's actually moving away from rights-based and constitutional values. And I think as a system and a judge who's been sitting in a constitutional court, it's important to recognize the fact that I've spent all my time upholding constitutional values.
Yeah.
I've spent my time recognizing constitutional rights, human rights, or basic rights, which I find at the core or at the basic. It's the basic issue in any issue. It's the basic thing. So if we start deviating from that, if we start deviating from those values and from protecting those values, then it's difficult to say what we should expect. And like you said, uncharted waters, only time will tell, whether these uncharted waters are for the better or not. But recognizing core values cannot change, no matter how uncharted the waters are.
Ladyship, for taking us through the rule of law, for taking us through regulation and markets, gender, the Constitution, and most of all, for helping us understand what the law might mean through a citizen's eyes. We are very privileged to have been able to speak to you. Thank you so much. And on behalf of CDPR and IGC, we're very grateful. Thank you, Ladyship.
Thank you for having me. And I hope that this discussion it helps people understand the court system.
Yes, certainly. Thank you.
Please subscribe so you never miss a podcast and comment below who you would like to see next.